Thank you, Ciarán. I welcome the opportunity to contribute to the debate on this Courts and Civil Law Bill, and I'd just like to start off by saying that I welcome the provisions, most of the provisions, or practically all of the provisions contained in the bill, and I think it is something that needs to be done. However, I would have some concerns in relation to the in-camera rule and the easing of the in-camera rule as envisaged within the legislation. I think all of us probably, and particularly since I've been here in this House, we receive a lot of communications from fathers who have gone through the family courts, complaining about the difficulties that they experience there. And there does appear to be a bias against fathers in the operation of the family courts, but it is very difficult, obviously, because of the in-camera rule, to actually get any information, any independent information, to see if that is actually the case. And it may be something that the bias is built in there in the legislation that the courts are working under in terms of family law, rather than actually in the operation of the courts themselves. But I think this easing of the in-camera rule may go some way to removing some of that perception of bias and some of the concerns that are there. But in reading just about this legislation and preparing for speaking here this evening on it, and reading the Ombudsman for Children's Office communication in relation to it, it did flag up a lot of some concerns, and I think there are concerns that the Minister should consider addressing at committee stage to make sure that this legislation becomes workable and practical as well. The Office for the Children's Ombudsman believe that a system for reporting should be rights compliant, systemic, sustainable, non-deterring and independent. And I was surprised to read that they don't believe that this bill meets any of those criteria. And I think they believe that it won't provide systemic information. It may lead to the identification of children and families in the courts, and may cause children to retract child abuse disclosures, and then doing that deter parties then from continuing on in the courts. And I think that's something that we do need to be very careful about. And I suppose, as other deputies have said, you'd need the wisdom of Solomon to maybe get it right at this stage in terms of legislation or that, but it's something that needs to be looked at, and probably when this legislation is passed, needs to be kept under very careful review as well, to ensure that that none of these problems arise where families could be identified with that. And the Minister in his contribution was stated that there's accordingly an absence of reliable information on the operation of the law in this area, which is not conducive to confidence in our system of family law and child protection. Sometimes I wonder whether the media can give you information that would be reliable as well in terms of the operation of any of the courts, and the nature of journalism and court reporting probably is that they wouldn't be allowed or given the time to go into the detail of the cases in the publications as well, so it may not lead actually to much useful information actually coming out of the courts, other than we may see some sort of voyeurism or whatever being operated in the media in relation to cases taking place in the courts, and I think that very carefully has to be protected against. And I know that the legislation provides that a judge can restrict access for the media in family law cases, but it is something that I suppose we just have to exercise caution on to ensure that it's done in a fair and proper way. And I think that the important thing, and probably the thing that's necessary in the reporting on the cases, is that there would be contemporaneous reports coming out, so that people can look at the legal issues and update themselves in terms of legal issues, and people can look and see what actually decisions are being made there that maybe could have an influence on their own situation, where they could understand it and lead to maybe people understanding actually what's happening there in the courts. And I note that the Family Law Reporting Project was operating on that basis, where barristers and solicitors were allowed in to sit in on court cases and write reports on them. But one of the problems with that was that the reports were delayed publication, and mightn't have contributed to the people's overall understanding of how the family courts worked. But I think that's something that we should be doing, and hopefully it can achieve what the Minister hopes that it will achieve in terms of creating a better public awareness and public understanding of the issues that go on within the family courts and how they actually work, and remove that perception, or contribute to removing that perception of bias that may be there from some members of the public. And indeed it would probably aid us in our work as well when we're dealing with people who feel hard done by and feel that they've been wronged by the family courts. We may be able to bring a better level of understanding when talking to them, and ease some of the difficulties that a lot of people that would be in contact with us would be extremely upset, and I think frustrated, and it is built up into a whole I think serious issue where maybe a bit more understanding could be, in a way, could ease it for them, but going through a very difficult family situation anyway, which I suppose people wouldn't take too well to, that may not help that much on it. But the other recommendations, just in relation to amendments to the Bankruptcy Act and the Personal Insolvency Act, I would agree with some of the speakers who raised concerns in relation to that. I know they say they're technical in nature, but I would have liked to see maybe the Minister amending I think it's section 105, where it allows the banks to extend the period that somebody could be in an insolvency procedure for. I think that's something that should have been removed from the Personal Insolvency Bill in the first place, and maybe consider that, Minister, that restricting the banks, because I think we have been too lenient on the banks and we have given them too much time, and we need to place some restriction on them to make sure that they deal with people in insolvency situations in a proper way, and in a way that allows them to recover and get their lives back on track again in the future. The appointment of the 2 additional Supreme Court judges, I would welcome that provision. I think it is something that needs to happen, and I note that it is an interim solution, and the Minister intends to create I think an appeal court on a separate footing, and we'll be debating that later on in the week, and there could be some concerns in relation to that legislation. But I think it is important that we increase the number of judges to allow that the courts can process more cases, because I think it is, when you're sitting maybe waiting for years for a case to come up before the courts, it does undermine the judicial system and undermine the operation of the courts, that there should be such massive delays in cases taking place.
Thank you, Chair.